Welcome to the DC Bar Labor and Employment Community and the Metropolitan Washington Employment Lawyers Association's May 2025 webinar, Muldrow, 1 year later, what's changed and what hasn't. I'm Scott Oswald and MWELA's Bench and Bar Committee Chair and your moderator for today's program. Before we begin, Deontay Sylvertooth from the DC Bar Labor and Employment Community has introductory remarks for us. Deontay?
Thank you, Scott, and hello, everyone. First and foremost, the DC Bar Labor and Employment Community is appreciative of the fact that we're able to partner with the Metropolitan Washington Employment Lawyers Association to provide this wonderful presentation today. I am more like the host at a restaurant. My job is to get you to the table and quickly move out the way so you can get to the main course. But I do want to let you know I'm the vice chair of the DC Labor and Employment Law Community. What that means, I just follow whatever Andrew tells me to do. But the labor and employment community involves everyone from the plaintiff side to the defense side, as well as judiciary, as well as agency counsel. So we welcome you to contact us with any information that you may need or want us to participate in. I do want to highlight, hopefully today we will have registration for a program on June 4th, which is an in-person program, limited slots with the Washington Field Office of the EEOC, where we'll have the director, the deputy director, the assistant regional attorney, the supervisory administrative judge, the ADR coordinator, the intake supervisor, the outreach and education coordinator, as well as myself, so we can have an intimate conversation with the Washington Field Office. So if you see that, please make sure you register because the space is limited. But again, we appreciate this time and we look forward to this wonderful presentation. Thank you, Scott.
Deontay, thank you. Now to our participants in today's roundtable. The Honorable Loren AliKhan is a United States District Judge on the U.S. District Court for the District of Columbia. Before joining the federal bench, Judge AliKhan served as a judge on the District of Columbia Court of Appeals and as the Deputy Solicitor General in the Office of the Attorney General for the District of Columbia. Andrew Adelman is a partner at the law firm of Correia and Puth. Andrew represents employees in matters under Title VII of the Civil Rights Act of 1964 and other employment statutes. Lindsey White is a principal at the law firm of Jackson Lewis. Lindsey represents employers under Title VII of the Civil Rights Act of 1964 and other employment statutes. I'll take your questions throughout the discussion portion of today's program. Just use the Q&A button located at the bottom of your Zoom screen. Let's begin with a primer from Andrew on the U.S. Supreme Court's seminal decision in Muldrow versus City of St. Louis. Andrew?
Hello, everyone. Thank you very much for joining us. And before I dive into the substance of at least this initial primer, I have to send a huge shout out, thank you to our law fellow on the DC Bar Labor and Employment Law Committee, Jan Key, who's a student at GW Law, who did a heck of a lot of research to get this presentation to what it was. So I believe she's here today. She deserves a shout out and lots of thanks from all of us. Diving into where things stood prior to the decision in Muldrow, which came out last April of 2024, a decision on Title VII, which we have the statute of the text here, prohibits, spells out hiring or discrimination as it relates to hiring, discharge, and with respect to other compensation terms, conditions, or privileges of employment on particular protected categories. Going into Muldrow, there was a circuit split over whether an employee challenging an adverse employment action under Title VII, other than hiring or discharging, and the facts of the case related to a transfer, must meet a kind of heightened threshold of harm, whether the adjective was significant, serious, or something similar. As the Supreme Court noted, yes in some circuits, the 1st, 2nd, 4th, 7th, 10th, and 11th, and no in the DC circuit. Particularly, there was an en banc decision just before Muldrow that said there was no such heightened objectively tangible harm requirement. Next slide. So Muldrow came to the Supreme Court. Just a bit about the facts. It was a sergeant at the City of St. Louis Police Department, a plainclothes officer who had been transferred from this pretty prestigious division, the Intelligence Division, to the department's a similar role not a similar role, it was not a similar role, to another role in the 5th District, which was more supervisory over patrol officers. And while her rank and pay remained the same, her responsibilities, perks, and schedule did not. And Sergeant Muldrow challenged the transfer as discriminatory based on her sex. The 8th Circuit disagreed, finding that she could not show that the transfer caused a materially significant disadvantage because of the substantial similarities in things like responsibilities, perks, and schedule. And the question presented to the Supreme Court was whether Title VII prohibits discrimination in transfer decisions absent a separate court determination that the transfer decision caused a significant disadvantage. Next slide. The decision, which was unanimous, which feels a rarity these days, particularly in employment matters, was the holding was that although an employee must show some harm from a forced transfer to prevail in a Title VII suit, she need not show that the injury satisfies a significance test. The decision authored by Justice Kagan looked at the text of Title VII, and the language discriminate against means treat worse. And that phrase and nothing else in the statute requires any sort of heightened significance requirements with respect to the adverse action. There's some great language in the decision. I encourage folks to read it. Title VII's prohibition against discrimination flatly prevents injury to individuals based on status without distinguishing between significant and less significant harms. Next slide. The court, in coming to this conclusion, kind of looked at decisions from the Court of Appeals that had held that certain adverse actions did not meet the standard of an adverse action under Title VII. So you had in the 4th Circuit a case where an engineering technician was assigned to work at a new job site, essentially working in this like really small wind tunnel, and the transfer did not have a significant detrimental effect, and therefore could not form the basis of a claim of discrimination. A decision from the 10th Circuit, a shipping worker is required to take a position involving only nighttime work, wasn't enough. And then another 4th Circuit decision, a school principal forced into a non-school-based administrative role supervising fewer employees, not enough. And the Supreme Court signals that all of these, it doesn't say directly, but get the impression that all of these were decided improperly under some heightened threshold showing of harm. Next slide. Justice Kavanaugh wrote what I'm going to say is a really great concurrence in this case, and kind of disagrees with the holding that you need to show some harm standard. Ultimately believes that the outcome is the same, that the ultimate guidance is going to be the same, but does not believe, pursuant to the text of Title VII, that there is a requirement that there be a showing of some harm in order to prove discrimination. In his words, the discrimination, the decision to move itself is the harm. And he writes at the end of his concurrence, kind of gives a couple of guideposts, at least in his opinion, that he believes are facts or factors that can help demonstrate what could show that harm, whether it's in money, time, job satisfaction, schedule, convenience, commuting costs, prestige, status, career prospects, interest level, perks, professional relationships, networking opportunities, effects on family obligations, or the like. Next slide. So since last April, the decision came out, we've seen courts wrestling or applying Muldrow in cases, particularly in the transfer context, but also as it relates to other employment actions that are other than hiring and firing. So we'll go through a couple of examples of those that courts have found did meet, and then we'll look at some that courts have found did not meet. In those that did meet the standard, the back decision out of the Second Circuit that a temporary transfer that it was only a week that was intended kind of as a pit stop before another transfer, that the employee viewed as a demotion and that others perceived to would have been a demotion was enough. Out of the Third Circuit, Russo, a suspension with pay might, under circumstances, be an adverse action. The Sixth Circuit, a transfer to a position where the plaintiff was not adequately trained for the roles. And then another transfer that denied him the opportunity for overtime pay, did not utilize the person's skills, and required him to work later hours by himself was enough. Next slide. This Seventh Circuit decision, I really like, encourage folks to read it. Thomas, deferred training. It was a decision about deferred training. Deferred training can mean deferred promotions or deferred raises. Denial of one's preferred vacation schedule can make the vacation less pleasant. And essentially someone was denied the week of vacation that they wanted was one of the facts. Not just because it may end up off season at the destination, also because the goal of vacation is to see family. And so if the employer considers those family circumstances when assigning shifts, it must do so without regard to color. The case was one of color discrimination because inability to care for a child is deeply felt loss for all parents. Next slide. So now looking at some appellate decisions that have found not enough adverse or not to meet the some harm standard. Rios out of the First Circuit, that a mere admonition by a supervisor without any formal consequences was not an adverse employment action. Williams out of the Sixth Circuit, that having an employee temporarily work from another office, in which, to be separated from another employee who was alleged to have been harassing them, being excluded from meetings unrelated to the job, instructed at a retirement party not to eat food that the employee didn't pay for, and prohibited from using company vehicles, along with a few other things, were not conditions of work that met the adverse action standard. Next slide. A few others, a reassignment that didn't change position, duties, salary, or benefits within a new office that was in the same building was not actionable. And then the lucky case out of the 11th Circuit, a female vice president assigned to perform administrative tasks, which she asserted diverted her attention away from her job duties, was not adverse when those duties were not outside of the terms and conditions of her employment. So lots of fact-specific determinations in these cases, both what is and what is not actionable, and we'll be talking about those in the context of our discussion later on. Next slide. Courts have also been wrestling with how to apply Muldrow in the context of hostile work environment claims. There's this decision at the Sixth Circuit that spent some time talking about it. And so if that's something that you're wrestling with, I encourage you to take a look at that. Which essentially says that the significant or the some harm standard applies to both type of claims, whether it's a discrete act or a hostile work environment. And that you have to show in a hostile work environment claim that although the conduct has to be severe or pervasive enough to violate Title VII, we again ask whether there was some harm as it applies to leaving employees worse off with respect to an employment term or condition. Next up. Some courts have been wrestling with what does severe or pervasive mean, and what does some harm mean, and what's the relationship between the two. We could talk about whether they're getting those right or wrong or not, probably in our discussion. And so there is some complexity there, and there is some courts are having to kind of figure out what that means. You have this decision out of New York where a court says that the severe probably a typo there. Severe or pervasive standard is higher than the some harm standard, and therefore there's a difference in terms of pleading with respect to a hostile work environment claim. Next slide. Muldrow has also been imported into retaliation claims, which the Supreme Court, in determining and kind of coming to its conclusion on the some harm standard, was very clear to distinguish between the standard for asserting adverse action under Title VII's prohibition against retaliation. The Supreme Court said that White has adopted a material adverse standard for reasons that are peculiar to the retaliation context. That test was meant to capture those and only those employer actions serious enough to dissuade a reasonable worker from making or supporting the charge of discrimination. And so I've only seen it in my research only came up with district courts kind of wrestling with it, not that it's come to the attention of a court of appeals, but some courts like the Western District of Texas saying that the adverse employment action for retaliation claims, this material adverse standard, is higher than the some harm Muldrow bar. And then like the Northern District of Illinois saying the adverse action for retaliation context is still lower than that which is required for discrimination claims. So lots still wrestling with that. Next slide. Just a few other fun issues that kind of came to my attention. No real case law yet so much, but things to be thinking about and things we'll be talking about, I think, in the context of our discussion. One is administrative exhaustion. Now that there is a some harm standard applied to adverse actions, there is a requirement that each action be administratively exhausted under Title VII, and see courts looking at only those issues which have been administrative exhausted, applying Muldrow to those. We'll get into the idea of jurisdiction, whether there are issues as it relates to jurisdiction as opposed to adverse actions, things that now meet the adverse action standard that don't, and what jurisdictions we can be potentially bringing claims in. And then whether Muldrow applies to statutes other than Title VII. I saw one or two decisions, the Central District of Illinois case looking at Title VII in the context of other whistleblower cases and applying a some harm standard to those. But and particularly the decision in Murray that came out, I believe, the year before, in the context of SOX. I think there's some shifting landscape, or at least some changes in what the adverse employment action is as it relates to other statutes. And that's the legal landscape as we see ourselves in today.
Andrew,
Scott?
Thank you. So let's move to the discussion portion of our program with client intake considerations pre-Muldrow. And Andrew, let's start with you. At intake, did some courts of appeals pre-Muldrow significant harm or material harm standard ever dissuade you from taking a case?
I think at the intake stage, the answer is no. Practicing in DC, we had the DC circuit previously holding that there was no, or at least no significance standard. But or I should say at the intakes, when we're initially having potential clients come to us, we're trying to suss out whether there's discriminatory animus there. Whether it's a decision to take them on as a client, we're certainly looking at whether those are cases that we want to both pursue in terms of informal resolution and in court. And we're looking at what are the strongest claims, what are the facts. What are the strong facts? What are the strong damages that we're going to be able to assert? And I think we're trying to look for the best cases and not just necessarily those that meet the threshold of whether there's an actionable cause of action there.
Okay. Lindsey, hello. Let's bring you into the conversation and talk a little about how we analyze harm actionable under Title VII post-Muldrow. So Muldrow makes clear that an employee need not show that the harm is material for the harm to be actionable. Some have asserted that employees need only show that the harm experienced was subjectively harmful rather than objectively harmful. Do you agree?
I think at this point we'll see case law will flesh this out, but my instinct is to agree with that. And I don't think that Muldrow has, I tend to agree with the concurrences that it hasn't really changed the standard. I think the standard has perhaps been misapplied. It's been clarified that this is the standard, but and I agree with Andrew, and that was an excellent PowerPoint, by the way. We're getting lots of questions. Can we circulate that? And that is going to be circulated. So, but you know, Judge Kavanaugh articulates all these different harms that could satisfy the some harm standard, and they're very individualized. So, you know, if somebody is transferred to a new position that requires commuting, for example, and that has an impact on their child care or schedule, that's unique to the worker, but that I believe that could constitute some harm.
So let's drill down into that. As you point out, Muldrow was a transfer case, but let's look at some other potential actions in the workplace that potentially could meet the standard. So can an employer's decision to subject an employee to a discriminatory performance improvement plan constitute some harm and be independently actionable post-Muldrow? Lindsey?
My defense colleagues on this call are probably not going to like my answers to a lot of these, but I do think the answer's yes, and I think that could have certainly been the case before Muldrow, but under Muldrow, you know, the PIP could certainly be some harm. I think to some extent it would also depend on what are the consequences of that PIP. Is that you know, is that a lot of employers, if you're on a performance improvement plan, you're not eligible for a promotion until you come off. You might not get a bonus that year. You might not get a pay raise, et cetera, et cetera. But even beyond that, I think that there's an argument that just the act of being put on the PIP alone can satisfy the some harm standard, even without sort of the extra tangible harm. And I know we'll talk about causation later. Obviously, these questions are all presuming that there is causation. I think all those things I just talked about, which is, does it impact your bonus, your promotion, whatever, those I think are going to go to the extent of damages. But to the fundamental question of, can that be discrimination? I think the answer has to be yes.
How about a downgrade in a performance review?
It would be the same for me. You know, you go from, on a 5-point scale, you go from a 4 to a 3, or, you know, a 3 to a 2. So you're moving down. If it's based on discrimination, I do think that's a violation. The actual harm is going to depend on the impact of that. You know, many companies, when they have to do a reduction in force, for example, a very easy thing to look at is performance reviews. You know, you can look at different jobs and things like that, your business needs, but all things being equal, if you've got to cut 10 people from the same job, you look at who are your best performers. So, you know, you cut the bottom 2, that seems facially very valid. But then if those 2 are able to come forward and say, well, look, this is actually, we believe it's because I'm female or because I'm Black, then all of a sudden that's really not such an objective criteria.
How about assigning an employee too much work?
That one is a more interesting one. I think that comes down to the subjective impact of that. I mean, my answer is yes, it could, especially if there's a demonstrated harm. Sometimes employees are loaded up on work because they're very good. And, you know, maybe their counterpart is not so good and maybe is being performance managed. And, you know, that person's just loaded up because they can handle it. There's an argument that there's some harm, I suppose, because it increases stress level and perhaps hours and things like that. But on the other hand, sometimes employees, get loaded up with work as, maybe there's an intention to see if they can really hack it. And if they can't, then that's the justification for a termination. So I think that would be a much more harmful situation than scenario one.
How about assigning an employee too little work?
That's the same thing. I mean, usually in that situation, people are assigned too little work for two reasons. One, there's a downturn in the business that necessitates less work. So if that's the case, I'm not sure that that's some harm, because that would be sort of a function of the fact that there's less work. Or viewing it in a different way, maybe that's the legitimate non-discriminatory reason for that, which would not be pretext. But then on the flip side of the too much work, sometimes when employers lose confidence in people, right, they take away the work. Maybe they're being performance managed or that kind of thing. But I think in the right circumstance that somebody could prove that that's some harm standard.
How about changing an employee's place of duty assignment permanently?
So that's an interesting one. I mean, I think Muldrow, at least the concurrences, acknowledge that could be some harm. Again, you see that sometimes companies do that because they want to cross-train their employees, and maybe there are multiple locations. And so they want to prepare somebody for a promotion. They want them to be, well-versed in the Reston, store, as well as the DC store, et cetera. So I think it goes back to the subjectivity of the particular action and ultimately the reason for the action. I mean, if it is because somebody is part of a protected class, that's going to be problematic. If it's because the business is trying to get somebody good experience to prepare them for a promotion, or even just to be able to fill in according to their business needs, I think that's going to be a legitimate non-discriminatory reason. So maybe that's sort of the new framework of how we look at these cases, which is the some harm standard is not hard to meet. I mean, we have 9 justices that can't agree on anything, and they agreed on that. So I think the lesson for the practitioners on all sides and, the neutrals is that the some harm standard is not going to be a big hurdle. It's really going to be shifted to what is the causation, and then is there, can the employer demonstrate that there was a legitimate reason for this, whatever action was taken.
So take us like in the inner sanctum here, when you're giving advice to your clients right now. Let's just take a situation where an employer is contemplating an employment action, but maybe hesitating after Muldrow. What's the advice that you're giving to your corporate clients?
I mean, my advice has not really changed since Muldrow. It's always, what's the reason for whatever action you're planning to take? Is it a legitimate business reason? And then is there a history of the business taking this action before? And if so, is this something that's applied universally between different protected classes? So that's really the conversation. I do think the add-on piece of that is that you need to be, aware of the fact that employees are likely going to be able to prove that just about anything constitutes some harm.
Thank you for your candor and transparency. Let's move to the pleading standards and how to plead these types of cases under Rule 8A. Judge AliKhan, I'd like to bring you into the conversation. First, I introduced you as the Deputy Solicitor General when I should have introduced you as the former Solicitor General. I apologize for that. Talk to us for a moment about your advice on pleading the types of harms that Lindsey just discussed in a federal court complaint.
So Thank you, and thank you very much for having me. I also agree the PowerPoint slide was excellent. And in looking at some of these cases out of my jurisdiction, I was surprised that there were a few saying there was no adverse action after Muldrow, because I think that it's very easy to plead in a post-Muldrow world. And so I think you have both, as Lindsey suggested, some subjective harms that you would need to plead. So if it is a change in shift that means that you miss school pickup or soccer practice, right? That is a subjective harm to you as the employee. And if that change has been made on the basis of a protected characteristic, then absolutely it's actionable under Title VII or the other federal statutes that incorporate the same language, or for those who practice in DC, the DC HRA, which is interpreted in accordance with the federal statutes. There also, I think, are still some just objective harms. And I think this is where Justice Kavanaugh's concurrence really informs the analysis. So if the supervisor puts out free donuts every Friday, no one would think that's affecting in a material way any term or condition of your employment. But if he hangs a sign that says whites only over those donuts, then those who are not white, have felt the harm of the discrimination. And in that case, the discrimination is the harm, the way that Justice Kavanaugh characterized it. And so I think depending on what kind of situation you're dealing with, you want to, in your complaint, tie the action to the adversity that your individual client is facing, right? Because a change of shift, if it was taken for completely permissible reasons, or a change of shift that doesn't actually affect you because you're happy to work the same hours as this shift or another shift, it doesn't impact your life in any way, then I think you're going to have a harder time getting to, getting past adverse action and getting to causation. Of course, Rule 8 says a short and plain statement. And so as judges don't want 500-page complaints with every, aggravation that someone has had in the workplace. But I do think in a post-Muldrow world, it makes sense to explain what you think the adverse actions are, and to the extent there are subjective consequences that flow from that, to make those clear. Because, my experience as both a former government attorney and as now a judge in a case where we have a lot of federal employment discrimination cases, the federal and local governments are almost always going to file a motion to dismiss and say that you haven't carried that initial burden. And you're going to want to point back to your complaint to say, here is why this was materially adverse, and then here is why there is causation.
So just taking that one step further, although 8A says that all we need is a short, plain statement, it sounds as if you're recommending a little more detail in the federal court complaint to withstand a motion to dismiss. Is that right?
That is right. I think maybe your mileage varies for those that are litigating against private employers, but I think never seen a motion to dismiss not be filed in an employment discrimination case by the government. So I think there you really need to be able to point the judge to the specific facts that you think you'll be able to prove up in discovery in order to clear that hurdle.
Judge AliKhan, you believe that a plaintiff's federal court complaint is strengthened when the plaintiff writes a good narrative, when the plaintiff tells a good story. Why?
Well, we're all readers and we like to be compelled when we're reading. And certainly you can have a boilerplate complaint that just states, the bare meager bones of the claim. But I think that presenting the case with a narrative that understands, here is this employee, here is what they did well, and here are the consequences that befell them that they believe to be on the basis of a protected trait and not on the basis of, an employer's strategic decision or a business need. And I think one of the troubles that I see sometimes is when you have kind of a scattershot list of grievances in the front of the complaint, and then just a few statements of causes of action where you're not really tying which allegation to which count of the complaint. It makes it very hard for a judge or a law clerk to really understand how you are advancing that claim. And I think it also makes it hard when you're then trying to oppose a motion to dismiss, because at that point you really do need to figure out which allegations are connected with which count. And I think writing your complaint, knowing that you're going to get a motion to dismiss and seeing how you can shore it up to withstand that motion to dismiss, I think really involves developing a compelling narrative.
Andrew, let's bring you back in. After Muldrow, are you pleading discrete discriminatory actions as separate counts in the complaints that you draft?
It depends. I think as we're looking at how to plead counts, and I'm wrestling with this now in a current case, you want to give yourself enough of a runway to be able to identify the causes of action and the bases of the claims, but you don't want to open it yourself up to too much, I guess, slicing and dicing, where you're then having to prove and make the case right out the gate of why each individual potential adverse action gets you into discovery. And so I think it depends on the facts of the case. It depends on the evidence of animus, depends on what the damages are and whether there's enough to tie it to each adverse action, even though there could be multiple things and many things in any particular case that meet the some harm standard. It might not be to your benefit to have a separate count for each individual one.
Judge AliKhan, when incorporating pre-termination harms in a complaint, what's your view about whether a plaintiff should break out each of the harms into a separate count or incorporate them clearly in one count?
I think it makes sense more to go sort of count by count or statutory provision by statutory provision. So you have your allegations in your complaint. You then say, count one, discrimination in violation of Title VII. And then I think you should in that, list what you see as the discrete instances of discrimination. Then I think you can do the same for retaliation and do the same for hostile work environment. I think by the time someone is bringing suit, they often have handful, if not more, of what they perceive to be adverse actions that were taken on the basis of a protected characteristic. And for those that might also feel like they're suffering discrimination on the basis of multiple protected characteristics, being able to really tie the allegations to like this was taken because of my race, or this was taken because of my gender, or this was taken on behalf of both. I think if you were to have each allegation in its own count, you'd end up with, a 200 count complaint, which might not be very easy. But I do think it is very helpful, as I alluded to earlier, to really know which allegations are doing work under which counts of your complaint. And I know in a lot of my opinions, when I have something like 10 or 15 allegations of discrimination, sometimes I'm trying to tie them to the discrete counts of the complaint. And I'm saying, is this allegation discrimination? Is this hostile work environment? Is this, retaliation? And, oftentimes it's not super clear from the timeline, right? Like, let's say you complain about your discriminatory conduct and then adverse actions are taken against you. Is that retaliation, or is that just additional discrimination, or is it both? And so I think, again, being kind of crystal clear as to, what allegations tie with which legal claims is just so beneficial when you're a judge trying to parse out a myriad of claims and figuring out how they survive a motion to dismiss or a motion for summary judgment.
Andrew mentioned hostile work environment claims. Judge AliKhan, since harms that are independently actionable harms can create a hostile work environment when taken together, when should a plaintiff aggregate the disparate claims into a hostile work environment count, and when shouldn't they?
I suspect that Andrew and Lindsey would have very different answers to this question, but I think there is a tendency when you have a discrimination claim to then also say, well, the sum of all of these allegations equals a hostile work environment. But there's a lot of case law in my circuit that says that you can't piggyback a hostile work environment claim just on discrete discrimination claims. And so I think that the lawyer and the client need to think carefully, like, are these discrete actions that were taken by different actors that would amount to discrimination, or were they a kind of campaign of harassment or ridicule that were really affecting the day-to-day life of the individual employee? And so, I sometimes credit folks when they bring a discrimination or retaliation claim and not a hostile work environment claim, because I think in some ways that can strengthen the benefit of their discrimination claim, because they can say, here are the 5 or 6 discrete instances where I felt like I was treated differently on the basis of a protected characteristic, and I should recover for that, but it did not rise to the level of this severe or pervasive such that it affected, the very terms and conditions of employment. And I think that post Muldrow, knowing that we have a sort of lower threshold, or the clarification that it's a very low threshold as to what adverse action is, I think really puts some daylight between pursuing individual discrimination claims and then pursuing a hostile work environment claim when it really kind of meets the higher standard articulated in the case law.
Thank you. Lindsey, let's take our first question from our audience. What do you think about recognition awards, whether they're actionable under Muldrow? For example, if an employer is regularly publicly recognizing male workers but not female workers for the same work, could that be a claim? What do you think?
Yes. And I think that is true regardless of Muldrow. You know, if you're recognizing men but not women for the same work, that's, I mean, you look at the some harm, there's certainly some harm. And the causation would be met, which would be because of sex. So I think absolutely. Recognition awards, you know, we don't have any additional facts, but, you know, I think the sheer act of recognizing somebody because, you know, you're recognizing a group, presumably that's publicized in some way. There might be an additional sort of, whether it's an awards ceremony or lunch or posting or compensation or even a gift card. And then those folks are potentially on the radar of management and other people for additional opportunities. So yes, I think that would satisfy certainly Muldrow.
Let's turn to statutes of limitations considerations after Muldrow. Lindsey, back to you. With each harm that an employee experiences arguably governed by its own separate statute of limitations, do you agree that each of the harms would trigger potentially a separate statute of limitation?
I think that's right. They seem like discrete acts to me. This isn't, you know, unless there's a hostile work environment theory where we're alleging, you know, sort of continuing violations here. I don't think that they would, I think each one would trigger its own actionable harm.
And if each harm triggers the running of its own statute of limitations, does Muldrow's holding incentivize employees to notify their employers of discrimination sooner than they otherwise might before Muldrow?
Yeah, that's an interesting question. I mean, does it incentivize them to tell their employers? Do you mean by the filing of a charge or just an informal complaint mechanism?
Well, let's take each.
Or either. Yeah.
Maybe just let their employer know because they know that the statute's running and if it can be resolved, they want to check in with their employer and make sure their employer knows.
Yeah, I mean, I do think it incentivizes employees to raise issues sooner. But at the same time, I think that's always been true. In a perfect world, you know, we all, you know, Scott, Andrew, and I can all work together with our respective clients and address issues before they need to be formally pursued as charges or as litigation. So, you know, representing employers, I always want to hear if employees have concerns right from the beginning, regardless of whether they're actionable or not, because even if they're not actionable, it's an employee relations issue. And when you have unhappy employees, that leads to a lot of other issues. So, I mean, I think the answer is Muldrow. I don't know that it really changes that, but it certainly shouldn't make employees delay when they would raise something. And then with respect to a statute of limitations issue, you know, filing a charge to toll, you know, a charge of discrimination to toll the statute. I think if each of the incidents in and of itself is actionable, you know, then that triggers a new statute of limitations. Certainly when I'm getting to the judge's point, when I'm defending something and we have these discrete actions, I'm trying to get them anything that's beyond, you know, the 300 days under, at least in Maryland or federal law, I'm trying to get anything kicked out, you know, that's untimely.
Andrew, now that more employer actions are considered actionable harm triggering the running of a statute of limitations clock, are you filing EEOC charges of discrimination earlier than you did before?
I think that's also an interesting question because, of course, we as lawyers know that, you know, maybe a move of an office or the failure to give an award is potentially discriminatory, but I don't necessarily know that our clients do. And so they might not come to us immediately after that, that event has happened in order to, assert a claim of discrimination. And maybe we're only getting the client, the potential client to our desk, sometime later when, another axe has fallen or another domino in the chain of, discriminatory events may have fallen. And so I think it depends on when they come to us, if the client's goals, depending on the client goals, if there's an opportunity to engage with the employer informally before having to kind of flick the switch of the administrative process, or if there's just maybe not enough time, or maybe they want to, it behooves us to set them up for a retaliation, a protected activity that might instigate, retaliation that results from it. So it really is fact dependent. It really matters. And really, it frankly matters when the client comes to us because, it depends on how many more days we have left on that 300-day clock.
Let's turn to choice of law and venue decisions. Lindsey, now that employees have more employment actions that are actionable, do employees have more jurisdictions in which to file their complaints if the employment decisions, for example, occurred in different jurisdictions?
Yes, I think the answer to that has to be yes. If they occurred in different jurisdictions, then the employee would have the choice of where to pursue them. And then, I think you get into the issue of, can you lump them all into one proceeding and thinking about that. But if I may just go back to Andrew's comment about intake and that they're not, his firm is not necessarily seeing an uptick, that makes a lot of sense to me because, well, I think that whether or not Muldrow actually changed the standard or clarified the standard, it's clear that the standard is clarified and that it's lower, than at least some people have thought. But, when you think about some harm, are employees wanting to take legal action against their employers for things that might be actionable but are not necessarily, more than sort of inconvenience, a change to commute time, a change to location? I'm not sure. So that makes sense to me, Andrew, that you're not seeing an uptick. That seems to me like something that would be, in an ideal world, again, addressed between the employer and the employee more informally.
Judge AliKhan, in a case in which the employee alleges several types of harm, some of which occurred in DC, but maybe the bulk of which occurred elsewhere, what should the employee counsel consider before choosing DC as her complaint filing venue?
Well, certainly they should consider the 3 venue provisions under Title VII, which is, where the action occurred, where the records are, and where they would have worked but for the discrimination. And if the plaintiff cannot be found in any of the defendant cannot be found in any of those, then, the defendant's home jurisdiction. I see a lot of cases under Title VII where folks will file in the district because that is the home jurisdiction of the defendant, even though they don't satisfy the first 3 prongs of Title VII. And I think it's, perhaps maybe just a misunderstanding, but you only get to that 4th prong if you can't find venue under the first 3. And so if you are someone who was, fired in Idaho and your records are in Idaho and you would have worked but for the discrimination in Idaho, you should not be suing, in the jurisdiction that is not Idaho. And so I think just really carefully thinking about, obviously this is the Title VII context, but, the Title VII venue applies in other federal employment discrimination statutes as well. But, assuming you do have several appropriate venues, and one of them is the District of Columbia, and again, I think this is a statement against my own interest. I think I said that to Scott when we were preparing for this, but DC judges see a lot of employment discrimination cases, and that's in part because most of the federal government is housed here. And so, and obviously we have a huge federal government population. And so I don't know the sort of statistics, but when I talk with judges in other jurisdictions, employment discrimination is a large part of a lot of courts' dockets, but I think it is an especially large part of our docket here. So I think when there is venue in DC, it behooves plaintiffs and defendants as well to have the case in DC because you have have clerks and judges that have a very long and steeped history with the relevant statutes. I also think that DC juries tend to be pretty sympathetic to employment discrimination plaintiffs. Again, my experience is almost exclusively limited to DC because that's where I've practiced and where I've been a judge. But when I was in, government practice, we would never want a case to go to a DC jury because we always thought, we had a better chance going before the judge than with a jury. And I guess to say that's because everyone, remembers having problems at work, right? There are all kinds of interpersonal disputes that people have in the employment context. And I think it's something that's very easy for a lawyer to articulate to a jury. There are a lot of other cases where you're talking about science or, complicated economic measures of damages that your individual juror doesn't personally relate to, but nearly everybody on your jury has worked at least one job in their life, right? And has probably had, bumps along the road. And so they understand the narrative that you're telling them. I did, if I could, there was one question in the chat about how non-federal employers don't automatically file motions to dismiss, and the participant was surprised to hear that the federal government always files such motions, and asked whether that practice of filing futile motions is ethically problematic as a waste of taxpayer dollars. And I just wanted to clarify that I think the government, both the federal government and local governments, are very differently situated than private plaintiffs. When a case comes in and the facts are bad and it's discrimination, the government is going to settle, right? And so if the case ends up going forward into motions practice, the reason I say they almost always file a motion to dismiss is because there's typically something that can be carved off, an allegation that wasn't administratively exhausted, something that's beyond the statute of limitations. And so I'm not saying that the government reflexively files motions that don't have a basis. I'm saying that, in cases where there are claims that are good and should go to discovery and claims that are, can be carved off, you'll see, partial motions to dismiss to try and just narrow down the scope of the claim. And particularly because in federal cases, we have such tight administrative exhaustion requirements, I think you want to make sure that you are bringing the most meritorious claims to the judge. And so I think that the two caveats, one of being more willing to settle, and then two, using it as a mechanism of narrowing the claims to where there really is a dispute, is why we see that motions practice happening in the government at a higher rate than we do in private practice.
You mentioned jurors in general and the fact that they might be able to empathize with the plaintiff because they themselves have been employees. In DC, Judge AliKhan, of course, we have maybe a higher percentage of government employees who are also on our jury pools. How do you see that playing out in the jury room in employment cases?
I think that's also very beneficial for employment discrimination plaintiffs. So unlike in the private sector where salaries and compensation and bonuses are the ways in which people are, rewarded. Everything is very lockstep in the government, right? And so some of the things that people care about are training opportunities, promotions, where their office is, what days they get off. So these much more kind of pedestrian or what we might see in a pre-Muldrow world as like not adverse, like those are kind of the bread and butter of the perks that a lot of federal employees see. And so I think they're very sympathetic to say, oh, you wanted to be on the 6th floor and you got to be on the 4th floor, like that is adverse because maybe you don't get as good of a view or you don't get to, be with your coworkers. And so I think because the nature of federal employment is so much more lockstep than what you see in the private sector, those jurors are more sympathetic to the stories that plaintiffs are telling them.
Thank you. Let's move to Muldrow's impact on dispositive motions practice generally. Lindsey, some contend that dispositive motions battleground in discrimination cases now shifts from what constitutes actionable harm to whether the employee has proven causation. Do you agree?
I think that's going to play out as being the real battleground, because if the some harm standard is fairly easy to prove and is a low bar, it's, we talked about this in our prep, it's almost like when the ADA was amended in 2009, and the purpose of the amendments was because Congress said it's become too cumbersome for plaintiffs to prove disabilities. We want to make it clear that proving a disability, several disabilities, should not be such a hurdle. So, then you have the regulations that articulated all of the different disabilities that should in most cases be presumed to constitute a disability. And that really has played out in the practice of ADA cases. That's not to say you don't sometimes litigate over coverage, but by and large, pre 2009, people were litigating over celiac disease and, conditions that now I think are just sort of assumed on both sides that constitutes a disability and it's not even really contested anymore. So I think this is going to have a similar effect unless something is extremely trivial. And, there will be litigation on the margins, definitely, and there will be probably even more litigation than just on the margins. But I do think eventually it is going to be a battleground over causation. So, and that's really going to be critical when employers are deciding what to do with various employment actions that could expose them in this area, to make sure that they have legitimate non-discriminatory business reasons for doing what they're doing, and that those are well documented and are going to be defensible in litigation.
Judge AliKhan, what advice do you have for defense counsel when considering whether to file dispositive motions on harms alleged in the complaint that fall short of the actual employment termination?
I mean, I think for defense counsel, knowing how low the standard is after Muldrow, I wouldn't waste a lot of ink fighting over whether something is adverse if the complaint either has something that seems objectively adverse or there are allegations that the harm did affect the individual because they're tour of duty interfered with their ability to pick up their kids, or their remote work schedule, affected their ability to go to doctor's appointments. And so, I think really post Muldrow, the battleground is causation. And so I think the defense counsel should spend more time either articulating why this was a decision that had nothing to do with any protected trait, or why there was a legitimate, non-discriminatory reason. So at the motion to dismiss stage, I think it's really, showing that there's absolutely no causation. And then once you get through discovery, obviously you'll have a lot more, hopefully, to show that you either can't have causation or there was a non-discriminatory reason for it.
Since the battleground now is in employment discrimination dispositive motions practice, it centers on whether the employee has shown causation. Let's turn to the standard for causation in circumstantial evidence cases. Judge AliKhan, some cases post Bostock v. Clayton County describe the difference between motivating factor and but-for causation as a difference in the quantum of causation evidence. Motivating factor requiring merely one form of pretext, and but-for requiring potentially more than one form of pretext. Where do you come out on this?
Thankfully, I've not had to come out on it yet. I know a few of my colleagues have. I think it's an interesting question. Since I joined the court about a year and a half ago, a lot of my cases are just at the motion to dismiss stage, where the question really is there just, any plausible allegation of causation that ties it together? And so I have not yet had the occasion to turn to summary judgment where that would those distinctions would make a difference. So I feel like I'm unprepared to give my view because I haven't yet had the chance to reckon with it.
Let's talk about trial of an employment case post Muldrow. Lindsey, statistics show that employees are more successful at trial with retaliation claims than discrimination claims. Do you think the balance here will tip towards discrimination claims post Muldrow?
That's going to be an interesting development to keep our eyes on. It makes sense that retaliation claims are more successful at trial because, of course, the employee does not have to prove that the underlying discrimination occurred. There has to be protected activity, which is a generous standard. You can even complain about something that turned out not to actually be discrimination, as long as you meet certain criteria. And there is the but-for standard there, but there's a reason why, if you look at the EEOC statistics, almost, so many of the charges have an add-on retaliation claim, and so many, EEOC decisions and court cases and whatever go forward where there's no discrimination, but there's, the retaliation claims survive. So it doesn't surprise me at all that that's the current status of where we are. Is that going to shift with Muldrow? I don't know, because the some harm has been clarified and grounded, so that should be easier for employees to prove, but then it really goes to the causation. And I don't think the causation has gotten any easier or harder to prove based on Muldrow. So, to me, it again goes to, I'm comparing it to the ADA amendments. It's, taking out really, we're not going to spend, as Judge AliKhan said, we're not spending a lot of ink on the some harm, but we're still going to fight very hard over the causation. So I think the answer is probably going to be no, but let's see how it plays out.
Well, let's talk now about proving harm at trial in a discrimination case. Lindsey, in Muldrow, as Andrew has reviewed with us, Justice Kavanaugh asserts in his concurring opinion that harm in time, satisfaction, schedule, convenience, commuting costs and time, prestige, status, career prospects, interest level, perks, professional relationships, networking opportunities, and effects on family obligations are all actionable harm. Let's discuss which of these types of harm are economic in nature and which are better described as compensatory and therefore subject to Title VII's compensatory damages cap. Let's begin with loss, for instance, of the company car. Is that properly classified as economic or compensatory in nature?
So a lot of these examples are going to be both. So the loss of a company car, if you're allowed to drive that outside of to and from work, which is sometimes the case, then I think certainly that's a loss of a compensatory, or that is a compensatory harm. But even just having a company car for commuting, which is more common, is very helpful. You're avoiding the wear and tear. Presumably they're paying for gas, they're maintaining the fleet of cars. So that is an economic harm. I think Andrew would try to argue it's also a compensatory harm. I don't know that I'm convinced on that, but I think we'd see the argument. And I do want to say, I think that juries, whether or not something can satisfy the standard, I do think that juries are going to be critical of these issues. And I think that plaintiffs need to be careful that they're not coming across as kind of just complaining about everything. So
how about time? Economic or compensatory?
Both, because economic, can have all sorts of impacts on family life, and family life is broad. It can mean all sorts of different things for people, caregiver status of parents or siblings or whatever, in addition to childcare. But also, if it's taking away, if you're now commuting and you're losing an hour on each side and you have people that are responsible for you, there's a change in your life that's happening. You're having to get, maybe you're paying for aftercare at school or whatever it is, but there's almost certainly going to be an economic impact on that.
How about a change in schedule, economic or compensatory?
I think both, for the same reasons that I just discussed. Yeah, I think there could be an economic component to that if the change in schedule results in you having to, hire additional people to essentially be you in those hours that you used to have available.
How about impact on professional relationships, economic or compensatory?
That could be both, because that could impact your promotional opportunities, which could impact your compensation, bonuses, anything like that. And then compensatory, if you've been working, striving for a certain career, and then you are not given access to people that can help you get to the next step of your career. I mean, I think there could be a compensatory part to that.
How about impact on networking opportunities, economic or compensatory?
Same thing, if it could long-term impact your compensation through promotions, or say somebody's in sales, and you don't have the same networking opportunities anymore. Well, that's part of your business that's been kind of closed off. So there could be a direct compensatory harm there, or direct financial harm rather, as well as compensatory for the same reasons. You're being denied the opportunity for promotion, which could have an emotional toll as well.
How about impact on prestige, economic or compensatory?
That seems more compensatory to me, but it could be economic if there's a correlation to other future opportunities. But with respect to that, strikes me more immediately as a compensatory harm, because nobody wants to have a loss in prestige. Even if there's no demotion in title or in pay, there is an impact of, a more prestigious job. And that's really what we, at least Muldrow's position.
In your view, Lindsey, would an employee need an expert to value any of these types of harms?
That's an interesting question. Maybe for some of the economic pieces, in terms of what are the future opportunities that somebody was not afforded access to, and what's the compensation there, and, kind of doing the math out. But retaining an expert for the, compensatory harms or the emotional harms seems like overkill. And I'm not sure how receptive a jury would be to that. And, I would, from the defense perspective, certainly try to, file a Daubert motion and exclude that kind of testimony.
Lindsey, should employee counsel list every type of harm as a separate damages line item on the verdict form, or combine them all into, let's say, the economic and then later the compensatory damages line items?
Are you asking from the employee perspective or the?
Just from your perspective, which do you think is the appropriate way to proceed?
I think there should be one line for, if the judge is evaluating, the jury is evaluating the sort of economic harm, then I think it should be one line. I mean, typically, at least for back pay, that's going to go to the judge. If it's, compensatory, I want one line. I don't want to give the jury multiple opportunities to, pay out.
Andrew, do you list every type of harm as a separate damages item on the verdict form, or combine them all into one economic damages line and one compensatory damages?
I hate that I'm about to agree with Lindsey, but I think I want a defensible verdict that's not going to be struck or appealed. And I think the more space that you give opportunities for a defense counsel to challenge the verdict because of its sufficiency of the evidence, or the proof of harm, the more opportunity you're litigating your case after your jury verdict. And with one line, you can't break that up into its component parts. And so I think that's going to be potentially your most defensible verdict. And so that's what I'll probably go with in terms of a compensatory damage, emotional distress line. If there's, on the economic side, if there are specific buckets you're looking to get damages for, I mean, I think those certainly should be broken up. But on the emotional distress component, I think I'm going to go for one line. The simplest verdict form is going to be the easiest for the jury to understand.
Judge AliKhan, having been a trial lawyer before becoming a judge, let's talk about the best ways to prove to a jury the types of harms that Justice Kavanaugh describes in his Muldrow concurrence. From your vantage point, what are some of the effective ways to show loss of things like satisfaction, convenience, prestige, status, and interest level to a jury?
So the plaintiff, I think, is always going to be the best witness. We might, in looking at dispositive motions, say that the lack of a training opportunity meets the standard of some harm for purposes of getting past a motion to dismiss because it, prevented or potentially prevented the employee from getting promotions because they didn't have necessary qualifications. At trial, you need to prove that up, right? You need to connect what you think the some harm was with what the impact of that was on you. Now, of course, some of it can be compensatory. Some of it can be just the discrimination itself, being made to feel unwelcome, being made to feel, humiliated or mistreated. But when you're talking about things that I think in a post-Chambers, post-Muldrow world might have been dismissed as not meeting the some harm standard, really is telling the story of, had I been able to do this, this is where I would be, and pointing, or even having testimony from other employees that had those opportunities and that led to promotions, bonuses, things of that nature. And so, I think that one of the benefits of Muldrow is that it makes it easier to get past dispositive motions. But I think when you get to the jury, they're still going to want to know, like, are you just complaining, as one of the other panelists said, or were you really suffering from discrimination, and what were the consequences that flowed from that?
So that's so fascinating. We talk about comparators in the context of liability, but you're really talking about comparators from the standpoint of damages, let's say a career trajectory for an employee. Do I have that right, Judge AliKhan?
So I think in certain circumstances, right, if you need a particular type of qualification in order to move up the ranks, right, if you need to have a certification and you're denied that opportunity, I think you would want to have sort of economic analysis of, had you received that training, here are your chances of getting that promotion, and here is what the benefits would be from that. And so, and it might be something like not being able to work a shift that allowed you to go to night school to get the degree that you would need to advance in your field, right? I think there you're going to have to, obviously you'd have to show that you would have been able to get those promotions anyway, but if you can kind of pinpoint the direct consequences and you have a comparator that was able to have those opportunities and was able to move up in the workforce, then, I think you do have a potential when you're looking at damages.
Let's touch on retaliation claims, and in particular the interrelationship between retaliation claims and discrimination claims for just a moment. Judge AliKhan, you've held that post-Muldrow and the DC Circuit's Chambers decision, the actionable harm discrimination standard does not extend to retaliation claims, which still require materially adverse action to be cognizable. As a practical matter, how is the harm standard between discrimination and retaliation different from your perspective?
I mean, the Supreme Court maintained the materially adverse. And so I think the types of actions that you were seeing go out pre-Muldrow are still going to go out post-Muldrow when it comes to retaliation. I think, at least from the judge's perspective, or at least my own perspective, I don't want to speak for my colleagues. In my opinions, when I'm looking at discrimination, as long as there is kind of an allegation of some harm, that's good enough for me to say it's been adequately pled, and then to go to causation. And so in discrimination claims, sometimes I might even assume without deciding that there was adverse action and, really fight the battle on causation. I don't do that in retaliation claims. I think adverse action is still a, robust freestanding element of the retaliation analysis. And so I do need to touch on it, and I do need to parse out, when there are several actions alleged, which of them are alleged to be ones that would dissuade a reasonable employee from complaining about improper behavior.
Thank you. Lindsey, back to you. Just talk about Muldrow's impact beyond Title VII for a moment. Some have opined that the Supreme Court's Muldrow ruling will extend to other discrimination statutes like the Age Discrimination and Employment Act, the Americans with Disabilities Act. Do you agree?
I do agree. And it has extended, some courts have already extended, especially the ADA, which is very often construed and interpreted the same way as Title VII. So I think we're definitely going to see an extension, at least in the ADA space. And we have started to see that so far.
Let's just touch briefly on corporate diversity, equity, and inclusion programs. Lindsey, do you see Muldrow having any impact on an employer's diversity, equity, and inclusion programs?
The EEOC itself has said that Muldrow has an impact on DEI programs. So the EEOC has come out with some guidance on DEI initiatives, which is publicly available. If anybody on this call has not read that, I'd really encourage you to go to the website. Maybe I don't know if we have a chat that's open to everybody, but maybe we can send it out with the slides. But the commission specifically calls out Muldrow as, applying to such efforts and views many DEI initiatives as potentially, exclusionary to other protected classes in a way that could satisfy the some harm standard.
Thank you. Andrew, let's zoom out for a minute, talk about the big picture from your perspective. What is Muldrow's larger message to the employee side bar?
I think the import of the case is really, as has kind of been demonstrated through the course of our discussion, is not to kind of slice and dice whether someone proves that the specific elements of a claim, but whether an employer's action was motivated by discrimination, and that the goal of Title VII is really intended, and our anti-discrimination statutes is really to root out decision-making based on improper characteristics. And like we've said, the discussion is now shifted to causation. We're now in the pretext having kind of forcefully more in the pretext conversation of whether we're able to prove and show that conduct has been based on impermissible considerations, and for employers to acknowledge or recognize that it's not a question of threshold, but it's a question of intent.
Thank you. Before we move to final thoughts, Judge AliKhan, you were a judge on the DC Court of Appeals before you were confirmed to the federal bench. What surprised you the most when you assumed your position as a federal district court judge?
A lot. Obviously, being a trial judge is very different from being an appellate judge. But, I think one thing that struck me was just the diversity of the DC Court of Appeals docket. You have a court with general jurisdiction that's hearing civil and criminal and administrative, but it's, family law and adverse possession and contracts cases. And, obviously some of that comes here under diversity, but the work of the federal district court, at least in DC, is a lot of employment discrimination, which is probably why I'm on this panel, a significant amount of APA and FOIA, and then obviously some just federal statutory and constitutional litigation. But my law clerks that came with me from the DC Court of Appeals to the district court joked that everything they learned on the bar exam was really relevant to their work on the DC Court of Appeals, because it is these hornbook law subjects, whereas here it's really about diving more into kind of statutory and administrative types of cases. I did see there was a question in the questions box about the recent DC Court of Appeals Sonmez decision, which seemed to adopt the pre-Muldrow material adversity standard for discrimination claims. I will caveat that I was originally on that panel, but I was confirmed, I think, either the day of or the week of when we heard argument. And so I was very promptly subbed out. So I don't have any insights into what the panel was thinking, but I'm curious to go back and look at that docket and see if the parties there filed a notice of supplemental authority about Muldrow, because I think, in the federal courts, especially in the DC circuit, because we had Chambers, and Chambers is a very close cousin of Muldrow, we had been thinking about these kinds of questions and what constitutes adverse action and some harm, dating back to 2023. But, I think Sonmez was argued in December of 2023 pre-Muldrow. And if nobody brought it to the court's attention, sometimes things do slip through the cracks. Like, obviously you want your clerks and the judges to pick up on it. But if you're not offering it to the to the court, who have, hundreds of cases at any given time, you hope for the best, but sometimes things do get missed. So, the DCHRA has a long history in the courts of being interpreted kind of coterminous with Title VII. And so I expect that to be the case here. I don't think that Sonmez was an intentional repudiation of Muldrow. I don't think they touched on Muldrow at all. So, it strikes me that maybe that part of the decision was written pre-Muldrow and, no one in the final round sort of thought to check it. But, my view, if I were, still litigating before the DC Court of Appeals, I would be, even as on the defense side, since I came from government, I would be applying the Muldrow standard for DCHRA cases.
Thank you. We are ready for final thoughts. Lindsey, start us off.
Responding to someone in the chat. So final thoughts, I think it's going to be really interesting to see how this plays out, particularly in the circuit courts, because that I think is going to be the real barometer of, is Muldrow extended to the ADA? Is Muldrow extended to the ADEA? How does Muldrow, if at all, impact sexual harassment claims? How, if at all, does Muldrow impact retaliation claims? So I think there's still a lot that needs to be fleshed out, but one thing is very clear, that to the extent that the standard was incorrect in other circuits or it's changed, it is, unequivocally not difficult for plaintiffs to show that there is some harm. So for the defense bar, I think we have to be focused on making sure that all of the decisions are appropriately and legally made and are well documented. And ideally, that means that we're involved with that process as the decisions are being made and not sort of on the back end with defending them.
Lindsey, thank you. Andrew.
As someone who had an opportunity to do really a deep dive into the case law post Muldrow, the cases that got dismissed, frankly, in my mind, just seemed so trivial, like the actions complained of. And so but not to say that the conduct couldn't have met some harm standard. And I think it really comes down to smart and effective pleading, showing that, whatever the adverse conduct is, that it really did have an adverse impact on either your own perception of your job, others' perception of your job, or the actual day-to-day of what your job was, or the impact on those around you, can ensure that things that may appear to be trivial are given the rightful place under Muldrow as being actionable. So yeah.
Judge AliKhan.
So picking up where Andrew was, I think it's going to be very interesting to see if there are still dismissals on adverse action and discrimination claims post Muldrow. I think if you look at my opinions, I either find that they have met the some harm standard or kind of assume without deciding, because even something very trivial, right? The donuts in the break room, if you're deprived of that on the basis of a protected characteristic, you've been discriminated against, right? And you should be able to bring a claim. I suppose a trouble or a potential, issue, I'm sort of at a loss for what the right word is for plaintiffs' lawyers is, and I think this has always been the case in employment discrimination, but maybe Muldrow exacerbates it by lowering the standard, is there are a lot of bad or annoying or, unfortunate things that happen in the workplace, right? It's a space where we spend a third of our lives, and there are always going to be interpersonal conflicts. And so when, clients are coming in and discussing, do I have a claim? I think it's really sometimes hard to separate out, like, yes, what happened to you was bad, but it's not illegal. Right? You were demoted because you were not a very good attorney, not because you were a woman. You were, so I think in a sort of post-Muldrow world where we know that all of these types of harms are actionable, it's going to be, I think, harder for the plaintiff's bar to really figure out the nuances of, is there a claim here? And, developing that, because again, there are a lot of bad things that happen that have nothing to do with a protected characteristic.
Judge AliKhan, thank you. Deontay.
Thank you. So I would say this, I've read the opinion, I've read a lot of cases post Muldrow on this issue, and I've harked back to a point that Justice Kagan indicates in her opinion in regards to dismissing the fact about the floodgates. But what I think Muldrow fails to recognize is the burden placed internally on organizations on trying to decipher complaints of internal discrimination, complaints about what is considered adverse. And I would particularly say, as a individual who's been on the plaintiff side and now as a shareholder at Ogletree on the defense side, but more importantly, as an agency counsel, as well as a special assistant U.S. attorney, a lot of the issues that we are seeing with clients on the federal sector side, having to go through those, these were a lot of issues that on the private side would be considered trivial and absolutely not adverse. But what we are seeing is the opposite of that, I think, particularly when it comes to employers trying to navigate what is adverse, what isn't adverse, with respect to how to navigate through their own internal policies and charges of discrimination, for instance. And so I would just end it with this, is that while the Supreme Court certainly put an end to the split, I think, in my view, it caused more questions than answers with respect to adverse actions.
Thanks to our panelists, Judge Loren AliKhan and Lindsey White, for participating in today's webinar. Special thanks to our panelist, Andrew Adelman, for organizing this webinar for us. Thank you, too, to Deontay Sylvertooth and our co-sponsor for today's program, the DC Bar Labor and Employment Community. Mark your calendars for the Metropolitan Washington Employment Lawyers Association's October 2025 webinar in conjunction with the Labor and Employment Law section of the Fairfax Bar Association, Out-of-Court Statements in Employment Cases, What's Admissible? That's on Thursday, October 16th at 1 p.m. Eastern Time. For all of our programming from the Metropolitan Washington Employment Lawyers Association, you can find us at www.mwela.org. Thanks for joining us today.